So, Torrens' elusive title, which is borrowing words from Professor Mapp's book from 1978. So, deed registration is a gold standard as ownership is conferred with a high degree of protection for the seller. And this is summarized as by Mapp as the virtue of the common law was that it provided security of ownership to a very high degree, and the vice was that it did so at the expense of the facility to transfer. Now we're already starting to make arguments that indexing can have an impact on that. But it does so at a cost. That indexing complexity associated with the draining chain of title from deeds was the catalyst that led to the Torrens title registration system. And here is a long quote from the Land Transfer Reform in Scotland from 1904. So, and all hands admitted that in points of simplicity, security, and cheapness, Torrens is the ideal mode of dealing with the problem of land transfer. It avoids the wearisome examination of the whole progress of titles on the occasion of every transaction in land. So the question remains, is a Torrens system still offering this simplicity, security, and cheapness? So in Torrens, it is really all about indexing. There's these three principles associated with that title registration system. You've got your mirror principle, title is a true reflection of the legal facts. The curtain principle, the title is credible, you need no further evidence to support its validity. And the indemnity principle. We know that the act of registration can make bad titles good, therefore indemnity provides a mud or money resolution to titling problems. So as we've demonstrated, if one can effectively index, then a mirror and curtain are unnecessary. And so the need for a Torrens title is actually a need for more effective indexing. So let's put that to one side and then start to have a look at some of the costs associated with Torrens title. So there's four major areas of title, Torrens titling costs, which we'll look at in turn. There's a rise of fraud and uncertainty surrounding immediate or deferred indefeasibility. There is issues around indexing associated with discharging non-ownership rights. There's issues around the Midas touch, what happens when you make bad things good, and the perennial issue of overriding interests. So fraud and uncertainty surrounding immediate or deferred indefeasibility. So since the 90s, there's been a rise in identity. Sorry, I'll put my voice back in. Since the 1990s, there's been a rise in identity fraud affecting registered land systems. And you've seen this in courts throughout the world, and they've discovered that their statutes present biojural ambiguity. And this is summarized by Pamela O'Connor. So in some of these jurisdictions, statutes which had long been assumed to incorporate either immediate or deferred indefeasibility have been judicially interpreted to embody the opposite rule. Now, this is quite a serious position. Law has been drafted with the assumption, not even just the assumption, with the presupposition that it will do things in a specific way, but judicially it's been interpreted to do things in a different way. So if lawmakers cannot accurately predict the types of indefeasibility their laws represent, then there's significant legal uncertainty. This is at a time when identity fraud and other cybersecurity related issues are on the increase because more and more registered are being moved into a digital setting. And so here, where we're looking at this relationship between fraud and uncertainty and blockchain immutability, start to have an increasing impact in terms of how titling and the whole registration system and how the whole registration system functions. There are indexing issues associated with discharging non-ownership rights. So go back to EC again from earlier on. So a real right which requires registration for its constitution will, under a system of registration of title, be listed in a unique title sheet which is made up for each parcel of land. Its existence and extent can then be discovered at a glance. Or can it? The true extent of original need cannot be discovered in a single Torrens title. Because if you are relating a deed for a very large area, it all gets back down to that representation. You have a deed of, say, smoke exclusion or pollution that says that you are restricted from burning coal, and that covers hundreds of square miles, and you have an ownership right for a 20 by 20 meter property. Well, you're not going to include the full extent of that original deed. You're just going to demonstrate that that 20 by 20 area is affected by this restriction to not burn coal. So the extent of an ownership right is represented insofar as it affects the owned land. Now that deed that represents the smokeless zone is actually fragmented and is split up within a title register to all of the deeds that it affects. What happens if that deed is repealed and discharged? How do we start to remove that right from every single title? That is a Herculean task, because the impact of that deed is fragmented in the way that it's affected, and it's not necessarily going to be indexed. So that indexing relationship between a deed and resultant title is potentially non-existent. So it gets back to that phrase, one can derive title from a register of deeds, but one cannot easily recreate deeds from a register of title. Midas touch, making bad things good. The act of registration under Torrens immediately creates an indefeasible title. When an invalid legal instrument is registered, the result is still an indefeasible title. So in Scotland, this is referred to as Midas touch, where the act of registration makes bad titles good, or more formally, a positive system operates bijurally, that is, with two concurrent systems of property law, and while the acquirer's title is good according to the rules of land registration, it remains bad according to the general law of property. So we get ourselves into a bit of a pickle in terms of the legal state between both of the legislative frameworks. So where this is discovered, the indemnity principle provides compensation, which is kind of fine in one way. However, the end result can be that the owner of the land has been deprived of land that they own by an invalid legal instrument, i.e. fraud has been committed and someone has sold what they did not own. This happens very rarely, but as we have seen with the increase in cybersecurity threats, it could happen more regularly. And this goes against all elements of sales of property acts and their equivalents. So this is going to be an increasingly problematic area. It also has an impact on first registration. So first registration can put neighbouring titles ownership at risk. And this is where a buffer period to resolve transactional errors is a sensible measure to effectively resolve defects. So the quote from Reed is important here. Early indications are of a surprisingly large number of cases where on first registration, the proprietor was mistakenly awarded part of a neighbour's property, and where without the possessory requirement, the neighbour's title would be at serious risk. So you're seeing issues there where at first registration, you're slowly, grabbing bits of land from your neighbour. No, it's not that it's done on purpose. It's just part of a registration error, a human error in terms of the process. But it has a significant impact. And equally, it's a very significant impact if there is no ability to redress that problem. First registration of Midas touch also has an impact on non-ownership rights. So it can put third-party rights at risk. So if a non-ownership right is neglected in that first registration transfer, then it's no longer legally valid. If that right happens to be a security representing many thousands of dollars, then that undermines the credibility of that security market. And and the thing is that deletion, if it goes on, is accepted by Midas touch because that's the way it works. Again, it's rare, but it can happen. Overriding interests. Overriding interests are a fact of life for many registers. And it essentially goes back to that element of the social contract which we live in, and what the law and what the system is doing are trying to reflect in terms of social need. There will be rights that are registered in other places, but over time we want to start to combine those in order to derive further social value. So overriding interests are rights which are held on other registers that may override what goes on in the register of title. This in and of itself militates against the mirror principle. The title sheet does not necessarily inform one of all the rights that encumber the land. That is in and of itself a problem. So in a well-indexed register, ownership or subjects, spatial relationships are articulated against overriding spatial rights held off register. Because if you've got the indexing set up properly, that's easy to do because it tends to be part of a spatial relationship. And this goes through into the approaches of a spatially enabled society as described by Studel and Rajabaford. So in theory, ownership and non-ownership elements can be decoupled and managed in this manner. And we'll talk about that in the next set of videos.